for the crime of criminally carrying a pistol after conviction of a crime. There are 2 counts in the indictment. The first count alleges in substance that on the 29th day of January 1992, the defendant, then being a person over the age of 16 years, feloniously did have and carry concealed upon his person a certain pistol and a certain revolver without a written license as prescribed by Section 137 of the Penal Law, licensing such possession and concealment, and in so doing, the indictment charges that he committed the crime of criminally having and concealing a firearm concealed upon his person after having been convicted of a crime. The first count of the indictment goes on to allege that prior to the 29th day of January 1992, the defendant, in due form of law, was convicted of a crime, to wit, breaking and entering upon a certain indictment then and there pending, and on the 13th day of December 1999 was duly sentenced following conviction. That allegation of the indictment is admitted by the defendant. The second count of the indictment alleges in substance that on the 29th day of January 1992, the defendant committed the crime of criminally having and possessing a firearm after having been convicted of a crime. And said count of the indictment goes on to allege that he was then and there over the age of 16 years and that he feloniously did have in his possession a certain pistol and revolver of a size which might be concealed upon the person without having a license permitting him to have possession of such an article. And the second count of the indictment reiterates the allegations as to the prior conviction, which prior conviction has been admitted, and which you may, for the purposes of this trial, consider as having been proved just the same as if witnesses were brought here to testify to the prior conviction. Gentlemen, before we come to a discussion of the provisions of the statute under which this defendant has been indicted, there are certain general principles pertaining to the trial of every case and to this trial, which the court will explain to you. First of all, the indictment which the court has just referred to is no proof of guilt. It is not evidence. It is a written accusation which charges this defendant with having committed this crime, but of itself it is no evidence that he is guilty of having committed it. Furthermore, the fact that the grand jury returned the indictment against the defendant is no proof whatsoever of his guilt. The defendant is not required to prove his innocence. The burden of proving his guilt rests upon the people. That burden never shifts from the people to the defendant. It continues at all times to rest upon the people the burden of proving the defendant's guilt. The defendant is presumed to be innocent. The trial started with that presumption in his favor. It continues at the present time, and it will continue while you are deliberating upon the evidence and until your verdict has been reached. You will not be justified in returning a verdict of guilty unless you are satisfied beyond a reasonable doubt of the defendant's guilt. Gentlemen, you will decide this case upon the evidence which consists of the verbal testimony of the witnesses and also of the exhibits which were received and marked in evidence. The exhibits are just as much a part of the evidence in this trial as the spoken word of the witnesses. Of course, any testimony that was stricken out by the court on motion of counsel is not part of the evidence, and the court instructs you that its rulings are not part of the evidence. Motions were made by learned counsel for the defendant to dismiss the counts of the indictments and to direct a verdict of acquittal in favor of the defendant. The court denied those motions. It was then dealing with questions of law. You will deal with the facts, and the court's rulings are not part of the evidence and will not be considered by you in any light whatsoever. They import no opinion on the part of the court as to the guilt or innocence of the defendant or as to what your verdict should be. The court may have occasion to refer to some of the evidence, but irrespective of what the court may say about the evidence, and no matter what counsel in their summation have said about it, you will be governed by your own recollection of what the evidence is. While you are deliberating, if a difference of opinion should arise among you as to what the testimony was as given by any witness, you may return to your seats in the jury box and have the official stenographer read from his minutes any portions of the testimony you might like to have read, to the end that your recollection concerning the same may be refreshed. Gentlemen, you are the sole judges of the facts. It is your duty to accept the law as the court will explain it to you. You are also the sole judges of the credibility of the witnesses. Those withdrawals were made. Well, I didn't want to take out When you approach a bank with a large amount of money, they don't want to give it to you in cash. So I took out 2 at a time. I figured they could deal with that. And I was preparing for a trip down to Simi Valley, and that money would have been for the business. I gave it to Arlen. Again in cash? Yes. And the next page, there's some other withdrawals. Can you tell us about those? On 11/26, there was a withdrawal for $50,000 in cash. That's a lot of cash. So that was actually $50,000 in cash? Yes, cash. Arlen said he wanted the money in cash. That it's best that way. And so you did it? Yeah, I had complete trust in him. Objection, non-responsive. The last part of the answer is non-responsive. Move to strike. It'll be stricken. Admonish the jurors. Jurors are ordered to disregard it. I think I already told you that any testimony stricken is to be disregarded. And you received the $50,000 cash. What did you physically do with the cash? Like I said, I was preparing for a trip down to Simi Valley, and I didn't know how to carry that much cash down there on the plane. I thought if I put it in my suitcase, it's going to go through the viewer, and I didn't know if